we know right now, really, there is only one definitional change to catastrophic impairment. As of September 1, 2010, a person who suffers an amputation or total and permanent loss of use of one arm or one leg is deemed catastrophic. There's another change. Len and Darcy talked about time frame issues, and unfortunately there's been a restriction. As you know, right now for clauses F and G, that is 55% or marked or severe mental or behavioral disorder, those tests for catastrophic impairment can only be done at 2 years unless a physician indicates that the condition is unlikely to cease to be CAT. And that was true about any variety of impairments before 2010, September 1. Now it's only going to be true about brain impairments. But I'm going to suggest to you that there's going to be increased likelihood that physicians will certify that a condition which includes a brain injury is unlikely to cease to be catastrophic impairment. And the reason that I say that, and let me suggest the time frame that you'll begin to get these declarations from physicians, is around the 6 to 8 month period after the accident. And the reason being is that if you have a brain injury or a combination of impairments that include a brain injury and you run out of treatment, every physician in and outside of this room is going to be concerned that there is going to be a deterioration in that person's impairment. And in fact, apart from their opinion now that they're catastrophically impaired, there's a greater likelihood that they and their symptoms and impairments will only increase over time. So I believe that opportunity will be used more often because we don't have much else, frankly, to get the question of catastrophic before an arbitrator or a judge in a time frame that can make a difference to people who will suffer significant deterioration in their injuries without treatment. However, taking a step back from the changes which this regulation authors for us, when we review all of the court and arbitration decisions dealing with a CAT issue, we learn that a holistic, inclusive approach is used to determine whether a person has suffered a catastrophic impairment. And that approach is to measure and add both the physical and the mental impairments to determine whole person impairment. That's been true ever since Debian and for each of the decisions coming thereafter. I'd like to talk about two recent cases that apply this holistic approach. They are the Pastori and Fournier decisions. And these decisions reveal how arbitrators assess mental and behavioral impairments. Arbitrators in courts have recognized that it's important to look to a range of healthcare professionals' opinions in order to have a complete impression of the whole person and the severity of those impairments. And Pastori and Fournier help demonstrate this approach. In both cases, and in others before them, arbitrators look to physicians, neuropsychologists, occupational therapists, and other healthcare professionals to help them determine whether the person has a catastrophic impairment. Now, there's a bit of a wrinkle we haven't talked about in great detail today, but Section 45 sub 2 says assessments for CAT determination must be done only by a physician, or if it's a brain impairment, they may also be done by a neuropsychologist. I've spoken to a number of CAT assessors in the room on this subject here, and there's a wide range of opinion on those. On what this section means. Some feel that it doesn't restrict them from working with a panel of other healthcare professionals in order to have a full understanding of the impairments when they submit their CAT application or rebuttal. And some feel that, it looks like we're looking at a physician's view on all of the areas that need to be examined as to whether a person has a catastrophic impairment. My suggestion is that there will, regardless of the way the section is interpreted, be continued reliance by arbitrators and judges and CAT assessors on you, on healthcare professionals working outside the sphere of physician or indeed neuropsychology to provide the information necessary to help people determine, arbitrators particularly, that people have suffered catastrophic impairments. Now, I guess my point is if you look at all of these decisions and you look at the arbitrators and the evidence before them, evaluating mental and behavioral disorders especially takes a team approach. And further, if we have to deal with the issue associated with the refusal of insurers to pay for reports to help lawyers help their clients get entitlement to catastrophic designation, the lawyers who are practicing in those spheres are going to have to step up and pay for the cost of those reports. Equally, if the process involves responding to IEs, and we've addressed the fact that there are no rebuttals available any further, but a good lawyer will prepare responding, will ask healthcare professionals who treat and assess their client to prepare responding reports to an insurer examination. If the insurer examination doesn't agree the person's catastrophic, I will want my neuropsychologist, my occupational therapist, and the other members of the team to address the failings of the IE to properly identify the impairments which would allow for the conclusion the person is catastrophically impaired. That means I am going to have to pay for the cost of those reports. No one welcomes that change, but that's a necessity of good practice in dispute resolution litigation. So specifically, to answer the question, if it's a team, who are the members? Members of the team should include OT, speech, physio, psychology, social worker, neuropsychologist, and kinesiologist, among others. A team approach is necessary because we are addressing, under mental and behavioral disorders, which is my focus today, 4 different aspects or types of function: activities of daily living, social function, concentration, or adaptation. Some of these are terms of art, so we'll explain these later. Now, if a person suffers a marked impairment in one or more of each of these 4 areas, they've suffered a catastrophic impairment. There's some consistency developing with the cases on that issue. So the definition of marked impairment: impairment levels significantly impede useful functioning. Those words mean some things to you, they mean different things to arbitrators, and sometimes different things to lawyers, but there is a body of law emanating from the Supreme Court of Canada that helps us to understand what significant means. And significant means more than minimal, and frankly more than insignificant, its opposite. Impede means hinder or delay. It does not mean prevent. And we can only determine the degree of a person's impairment if we have a baseline of their pre-accident function in each of these 4 areas. Let's look at the definition of ADLs used by the AMA guides. It's quite a range, and under each of these categories there are other indicia at page 312 of the guides as to what constitutes ADLs and how they should be measured. When I speak of the guides, I'm talking about the American Medical Association Guides to the Evaluation of Permanent Impairment. So let's consider these categories. Who can or should assess the ADLs listed? Well, if we think of care, hygiene, activity and communication, and other functions, we can easily bring to mind occupational therapy, nurse, physio. If we think of communication, sensory functions, social and recreational activities, and other functions, we can think of helpful comment coming from speech therapists, speech-language pathologist, psychologist, social worker, neuropsychologist, kinesiologist, recreational therapist. And as you wend your way through the cases, you'll find that this kind of evidence is relied upon by arbitrators. This is helpful. It helps to show the whole person, and we will continue to rely on it. Let's look at each of the other spheres or aspects of function that need to be considered for determining marked mental or behavioral disorder. Social functioning is the second category that has to be looked at. And for this aspect of functioning, the AMA guides tell us to look at not only different kinds of social functioning, but different ways of social functioning and how different ways are impaired. Again, different members of the team will be necessary to help us get a full understanding of these impairments. They will include occupational therapy in this segment, occupational therapy, social worker, psychologist, speech-language pathologist, and neuropsychologist is my suggestion here. And frankly, if I am proceeding to an arbitration or a court hearing on a catastrophic impairment issue, and I have those members of the team having weighed in about these impairments on one hand, and I have a physician as the only witness being called on the other side, I believe it's quite patent as to whether the arbitrator will feel a more in-depth exploration of these impairments will have been made by the plaintiff or the insurer. The next area is concentration, persistence, and pace. Again, these are words that are tough to interpret on their face, so let me give you the background. It means basically ability to sustain focus to permit timely completion of tasks. And so to address this aspect of functioning, it requires assessment of physical, psychological, and mental abilities. And again, a range of therapists can best comment on this degree of function: occupational therapy, physiotherapy, kinesiologist, psychologist, neuropsychologist. Next area, adaptation. Or adaptation means specifically deterioration in a work or work-like setting. So whether a person withdraws or decompensates from the stressful circumstances that a work or work-like setting places them into, and when they have decompensation or withdrawal, if that affects their ADLs, social relationships, or in completing tasks, that needs to be measured. So if a person works a whole day or a half day but can't interact with family and goes to bed, that's an indication of a kind of measurement or information that's important in determining adaptation here. So we think of mental and behavioral disorders, we think automatically of things relating to the psychological sphere. But if we look at the next couple of cases, the Pastori and the Fournier decisions, we see that we have to look beyond psychological indicia to determine whether there's a mental or behavioral disorder. So these next two cases show that we need to consider the interrelationship between psychological and physical impairments. And that's indeed what the arbitrators have done in both of these cases. Pastori and Aviva is the first one I'd like to discuss. Miss Pastori was 66. She was a homemaker and caregiver at home. It was found as a result of the accident, she suffered physical limitations and she suffered pain, and these two impairments were intertwined inextricably, according to the arbitrator. So an assessor, and indeed there were assessors that were involved, a catastrophic DAC was involved, they have to look at how the pain affects the physical function. And as part of the catastrophic assessment, there was an occupational therapist, and the occupational therapist looked at the impact of function on the psychological impairments and vice versa. So for instance, if you see from this list, these are elements of impairment that seem somehow to relate to psychological, mental, or behavioral problems. But equally, you will see that information was brought by the occupational therapist and others to the arbitrator that as to the level of function that Ms. Pastori had before the accident, both physically and emotionally. So she was an avid churchgoer, she was active socially, she did her own housekeeping and cooking for her family, including her husband. She cared for her husband whose health was impaired, and she participated in physical exercise outside the home as well. Very, very important part of the process of the assessment for us to establish a baseline through understanding the level of ability before the accident. And equally, both OT, CAT-DAC, and the arbitrator looked at post-accident function, and there was a very significant reversal here. Instead of caring for the husband indeed cared for her, and she led a sedentary life, leading to her needing to be on the couch most of the day because of her pain and other limitations. Other post-accident function problems she had: she needed a walker, she couldn't use a bus, she couldn't climb stairs properly, she couldn't at all participate in her social or recreational pre-accident needs, and she needs attendant care. This will be the first time, but not the last, that I mentioned attendant care as an important indicator as to whether there's a mental or behavioral disorder. So this left the arbitrator with the opportunity to look at how functional she was before, compare with how dysfunctional she was post-accident. Indeed, the arbitrator did. And he, having compared pre- and post-accident function, found that before she was self-sufficient, now she's almost completely dependent. She also found that although pain is considered as a separate category under the AMA guides, there was reason to look at pain under section 14, so under chapter 14 of the guides, marked and behavioral impairments, to help us determine whether, in fact, pain was a source on its own of a marked impairment of a mental or behavioral disorder. So, having wrestled with this issue, because the guides suggest that pain there is recognition within the guides of the fact that pain exists, but it suggested that the percentages of impairment that are found to relate to pain should be linked to the physical problems. And so, for instance, if I've got a bad knee and I've got a problem with my knee and it causes me pain, then I should look to the chapter related to the orthopedic issues, musculoskeletal impairments, and give a percentage number related to not only the functional issue, but the pain associated with that functional issue. The arbitrator puzzled over that, and the arbitrator found that where the psychological problem was intertwined with the physical problem, that it was appropriate to look to Chapter 14 and to assess a mental and behavioral disorder where the two could not be undone from each other. So despite the fact that the guides suggested that pain was separate and already included in physical function percentages, the arbitrator's decision that it should be used on its own to determine whether or not a person with a pain problem has a marked mental or behavioral impairment, the arbitrator's decision that it could be looked at entirely on its own as a source for a marked impairment was upheld on appeal by the director's delegate, Arbitrator Blackman. So we have a decision by an arbitrator which says, I can't sever out pain from the problems, the physical problems that produce that pain. So I'm going to include those two areas of dysfunction together, and I'm going to recognize when I look at the pre- and post-accident function that there's a significant change, and on that basis the arbitrator found and the CATAC found that there was a marked impairment. The person was deemed catastrophic. The insurer appealed, but it was upheld on appeal. Back to, I guess, a comment that I'd made earlier. We do know that one marked impairment is CAT. There's a bit of an irony here, which I'll mention now, in that when a person does a catastrophic impairment under the guides, one looks to Chapter 14, decides whether they have one marked impairment. In this case, the arbitrator found that Ms. Pastori had one marked impairment in her activities of daily living alone. Under social functioning, adaptation, and the fourth, there was no marked impairment. Now, the secondary part of the arbitrator's responsibility is to look at the degree to which mental function is impaired, not in Chapter 14, but for the purposes of assigning a whole person impairment percentage. So, to the extent that we know physical function is evaluated in terms of a percentage, and psychological function is evaluated in terms of whether it's mild, moderate, marked, or severe, if the arbitrator finds that the psychological function is only moderate, the arbitrator's job is not done. They have then to go back to Chapter 4 and say, well, if I'm to assign a percentage to the level of psychological impairment, what is that percentage? And I need to assign that percentage so that I can add that then to the physical whole person impairment that I've already assigned. So ironically here, in Ms. Pastori's case, the arbitrator gave a 22% rating for her mental and physical for her mental impairments, which satisfies only the level of moderate impairment. So although she was only moderately impaired with 22%, because there's the availability to find her catastrophic based on one marked impairment, under Chapter 14 she was deemed catastrophic. The next case involves Mr. Fournier, who was a 45-year-old cyclist who suffered a really bad ankle injury requiring surgery when he was struck from behind. He had depression, anxiety, post-traumatic stress disorder, and pain as a result of this injury. Now, again, there was a reliance on the occupational therapist to assist in giving information to help CAT determination. As part of the CAT assessment, the OT did a functional ability evaluation. Equally, there was an insurer examiner, and the insurer examiner found that the pain disorder was related to the foot and not psychological factors. So the insurer examiner basically told the arbitrator in his evidence that I've lumped in the pain problem in my assessment of a percentage whole person impairment on the physical side. So he's got a bad ankle. I say that that should be a 40% whole person impairment, and I include pain as part of that determination. The arbitrator rejected that approach, and here's part of the evidence that was available to the arbitrator on that issue. Dr. Mirsky, who's a psychiatrist, there was a psychologist as well involved, and Dr. Mirsky reviewed the psychologist's report and found marked impairment under Chapter 14 because of pain. In fact, he went to Chapter 15, which is a chapter in the AMA guides specifically devoted to pain, and said, part of the reason why I find he's got a catastrophic impairment under Chapter 14 is because he's got a pain problem which is recognized under Chapter 15. So again, Fournier is an example of a case in which pain was incorporated by both the assessors and the arbitrator into a Chapter 14 analysis. So we can say then that there is a trend to accept pain on its own and its combined effect with physical function as a basis for determining that a person has a marked behavioral or mental impairment. So I've got some conclusions that I'd like to share with you. First is that when you have clients who have suffered significant physical impairments with some psychological pain or mental impairments, or if you have clients who have modest physical problems but significant psychological problems, then there's a really important need for an assessment to be done that captures their pre-accident ability, compares it with their post, and will be relied upon by lawyers to help determine whether the person sustained a catastrophic impairment. Now, in terms of catastrophic impairment, a person is catastrophic if the intertwined physical and psychological or pain impairments significantly impede useful functioning. That's an important phrase. That's the one you have to measure when you're performing your assessment. I'd also like to talk about some signs that a client may have a marked impairment. If the client requires attendant care on an indefinite basis, then one should consider whether they have a marked impairment. Or if a comparison of the pre- and post-accident function shows a big change between the two, again, there's consideration that the person may have a marked impairment. Remember that the quality as well as the quantity of the function are both important measurements. In terms of other points to remember, if a person has a mental or behavioral impairment that is not marked, the arbitrator will also use your report to help assign a percentage, which can then be added to the physical function to determine whole person impairment. And finally, I guess I should, if it hasn't been evident already, lawyers will provide the best help to their clients who are in need of or who should be assessed for a determination as to whether they have a catastrophic impairment if they ask members of the healthcare team, the multidisciplinary team, for reports that identify all of the impairments, show how much function the client has lost as a result of their physical and cognitive, psychological impairments. And we look to you, again, as members of our team in the future, in an era in which, with so little money available for non-catastrophic clients, we search under all available information to determine whether indeed you've got a client who we should consider in approaching an arbitrator to have that client found as having sustained a catastrophic impairment. I appreciate that. Thank you.